Good afternoon, everybody. Welcome to Venable's July Advertising Law webinar. And if you are not on summer vacation and you've decided to join us, thank you for that. If you are on summer vacation and you decided to join us, I question your priorities, but thank you for being here also. Today we will be talking about consumer protection enforcement by state attorneys general. Very hot topic for advertisers and marketers, as I expect a lot of you listening in know already. You know, if you were to turn back the clock a little bit to the end of 2016, early 2017, I think that a lot of us who represent advertisers, telemarketers, fundraisers, lenders, and other businesses before regulators were wondering how the change in administration would impact all of you. And the smart money at the time was that we would see a downtick in federal consumer protection enforcement and a corresponding uptick in state AG enforcement to pick up the slack. And 2.5 years later, I think we can say that we were at least half right. On the federal side, seems to have been a downtick, at least at the Consumer Financial Protection Bureau, particularly with the change in leadership there, although even there we're seeing some cases being filed recently out of the Bureau. For those of us who practice in front of the Federal Trade Commission, our dance cards are full, and we're seeing a very robust consumer protection agenda, even with a 3-2 Republican administration. But we certainly hit it on the head when it comes to the states. State AG consumer protection enforcement is robust. It is nationwide. It is not just the usual suspects like New York and California and say Massachusetts, particularly for some business practices and in some industries, and I'm thinking of things like telemarketing robocalls or student debt collection. This is bipartisan and it's very broad. So if you are a national advertiser, you certainly want to pay attention to the state AGs, and that's why we're here today. My name is Eric Berman. I am a partner at Venable in our advertising and also our nonprofit practices. Mary Gardner, my colleague, is with us. Mary also practices in the advertising group, represents marketers, also insurance companies. And we are very, very happy to be joined by an old friend, Jillian Andrews. And until recently, Jillian was a deputy attorney general and assistant director of the Consumer Protection Unit in the Delaware Attorney General's office, and a couple of months ago also joined the dark side and now practices in private practice in Wilmington at Heyman, Inario, Gattuso, and Herzl. We are thrilled that she joined us today to offer her very good insights as a former recent regulator, particularly coming from a state that I think she and I would both agree punched above its weight class in consumer protection enforcement. With that, we'll get going. Housekeeping, we welcome questions. I believe that there is a chat box function that allows you to enter questions, and we can take those toward the end of the hour. Also, this is eligible for continuing legal, continuing legal education credit, and we'll be announcing the CLE code on the chat feature toward the end. So you're an advertiser. Why should you pay attention to the state AGs? State AGs have broad oversight and investigatory authority over conduct reaching into their state. All 50 states and the District of Columbia have enacted consumer protection laws. We usually refer to these as unfair and deceptive acts and practices, or UDAP statutes. We refer to some of these laws as little FTC acts because they are modeled on, or in some cases, they're essentially a cut and paste of Section 5 of the FTC Act. And in fact, in about half the state, at least the last time I checked, about half the states have UDAP statutes with explicit provisions where the state legislature says, hey, it's our intent that our UDAP law is viewed as being consistent with the FTC Act. We want our courts, our state courts, to be guided by FTC interpretations and federal court decisions analyzing the FTC Act. Now, having said that, there is a striking lack of unanimity among the state UDAP laws. It is not as simple as deceptive practices are unlawful, and let's leave it at that, and there's sort of a nationwide standard. Even given what I just said about an effort toward state consistency with the FTC, what you'll note is that at the federal level, we're talking in very broad strokes, right? So Section 5 of the FTC Act simply prohibits unfair or deceptive acts or practices in or affecting commerce. What is an unfair or deceptive act or practice under Section 5 is something that has been carved out over the past century plus by court decisions, by publicly available settlement documents like consent decrees, where we sort of get to see the contours of what the FTC has been able to achieve in terms of relief, and by other things like business guidance documents and consumer guidance documents. So that's the federal, very broad statute, and then we fill in the blanks with other sources. A lot of state UDAP laws are quite different. And so they'll say something like, it is a deceptive act violates this chapter, and then the law will go on to enumerate 24 specific types of conduct that the legislature deems to be deceptive. And again, there's not a lot of unanimity here. So, if you are an advertiser and you've been contacted by a state attorney general as part of an inquiry or as part of an investigation, I would counsel you that it is probably a mistake to say, Michigan reached out to us, let's just dust off the response that we gave to Utah last year. It's all the same thing, because Utah's statute says that it is a deceptive act or practice if a supplier knowingly or intentionally does the following, and then follows with a non-exhaustive list of about 25 different things. Whereas Michigan's statute doesn't have a knowledge or intent requirement and contains what I read to be an exhaustive list of about 40 different things. So, pay attention to the statute, the UDAP law of the state that you're dealing with, and really tailor your defense and your advocacy and your responses accordingly. Beyond UDAP laws, state AGs also enforce industry-specific laws. So, for example, things like state telephone solicitation acts, charitable solicitation laws, prize promotion laws. There's been a recent state of contract subscription auto renewal laws, like that coming out of California. DC has a new one. Those are examples of sort of industry-specific laws that are separate from UDAP, but really are largely complementary, we think, to those laws, and are also enforced by state AGs. I think the general point here is state AGs have broad authority. The doctrine of parens patriae allows them to represent citizens residing in their respective states in what are essentially consumer class actions. State AGs can seek monetary penalties, they can seek injunctions and equitable relief, they can seek declaratory relief. Like the FTC, we've seen states march into court seeking temporary restraining orders and asset freezes. We're seeing that right now as we speak. And some states are quite aggressive and are pushing the envelope in terms of the relief that they can get. Utah is currently trying to seek nationwide relief against an actor in a case. We'll see how that plays out, and we're monitoring it. But that's an example of very heightened and aggressive state AG enforcement. So we have state AGs with broad consumer protection authority. What are the tools in their tool shed, so to speak, that help them implement their consumer protection mandate? And on this slide, we've listed a few. This is a non-exhaustive list, but informal information requests, certainly formal compulsory process, which I'll gloss over because I know that Jillian will talk about that in more detail later. Let me say a quick word about informal or voluntary information requests. We put sarcasm quotes around the word informal. We did that intentionally. I would commend advertisers who receive a letter or an email, and we've seen this both ways. Something short of a subpoena or a CID, but something that still requests information or documents from a business. Ignore those at your peril. They are voluntary in name only. I think that it is worth your time to determine exactly what the AG's office is looking for, cut the wheat from the chaff, so to speak, and try to get them some information that is useful to them so that they can move on. Because this isn't compulsory process, there is certainly some wiggle room, some ability for you to shape the narrative in terms of how you respond. Sometimes you can answer the question you wish they had asked, not the question that they had asked. But you don't want to get too cute, and you don't want to ignore these entirely, because it is no trouble at all for a regulator to simply issue you a CID or a subpoena, and there are significant consequences to fail to substantially comply with those. Again, we'll talk about CIDs and subpoenas later. Suffice it to say, for now, CIDs are really a preferred investigative tool in our experience with regulators. They don't require court approval. Oftentimes, and this is true with the Federal Trade Commission as well, oftentimes are a little bit broader in scope than subpoenas. Either way, these are things that can be negotiated, and that's what you'll want to do. You'll want to negotiate the scope of the request. You'll want to negotiate the relevant time period that is covered by the request. You'll want to give yourself a little bit of breathing room in terms of how you comply and the timeline for that. It's not uncommon to see regulators agree to sort of a rolling production that is staged in waves, because responding to this stuff really can be burdensome for your business or your charitable organization, as the case may be. I think that there are some nonprofits listening today also, and this applies to you with equal weight as it does to for-profit businesses. We mentioned other investigative tools. We have secret shopping here, something that's sort of on top of mind for me. I know Jillian has thoughts on this too. As you conduct your business, I would commend you to pretend that there is someone from your local state AG's office, or perhaps someone from the Federal Trade Commission, sitting in your classroom if you are operating a sort of coaching and mentoring type business, or conducting a consumer sales transaction on your website, taking it all the way through to entering personal information and credit card information, and then trying to cancel to see if you comply with, ROSCA and other and state analogs, things like that. So, that is definitely a tool that we've seen being used. Our practice, when we're made aware of this, is to ask for a recording of the secret shop if there is one. We've had some success getting that, or at least a transcript of that, even if it's not strictly necessary for the regulator to give it to us. But we think as a matter of due process, it's a nice thing to ask for, and usually you can get it. Of course, there are other ways that state AGs engage in consumer protection activities beyond pure law enforcement investigations of specific businesses, right? They hold public hearings and panel discussions on topics of public importance. They conduct studies. They hold workshops, oftentimes in partnership with the FTC. They issue written reports. State AGs often lend their voice to federal proceedings, or they advocate for federal action. So, as a recent example, just a few days ago, we saw a group of 18 state attorneys general write a letter to the House Energy and Commerce Committee heads supporting the passage of anti-asbestos legislation. That's something that happens with some regularity, I think. 2 weeks ago, we saw 25 Democratic attorneys general file comments with the CFPB concerning its overdraft rule. States do this commonly. It's sort of another form of consumer protection that they engage in. And finally, there's what we call consumer education. And I'm reminded of a talk I gave a few years ago with someone I know that Jillian knows well, a state AG lawyer from New York, who made a point of saying that her office's view was that its job was not just to catch bad actors doing bad things. That's part of it, but a lot of it is to help good actors, good businesses, continue to behave compliantly, and to help consumers avoid common scams. And so education pieces, oftentimes in the form of, if not workshops, press releases, is a big thing. Doesn't utilize a lot of resources by the AG's office. A lot of times the stuff is seasonal. In March, you'll see notices warning you against IRS scams, which people still fall for, including my mom, who I don't think is listening. Or in the fall, you might see an Attorney General website post something about veterans charity scams, because that's when Veterans Day is. And of course, at the end of the year, the scams, knowing that people often give charitable donations by the end of the calendar and tax year, warning people against nefarious conduct there. So, all of these things, and again, it's not an exhaustive list, are what we see AGs doing as part of their consumer protection mission. I'm not going to spend much time on this next slide. This is largely more of the same. The point of this schematic is really just designed to remind us that state attorneys general don't work in isolation, right? As we said, they're advocating to Congress. They're partnering with the Federal Trade Commission. They're partnering with the CFPB, the FCC, the Department of Justice, and other federal law enforcers. They're cooperating in public workshops. They're filing comments with these agencies. They're receiving input from consumers. They're receiving input from watchdog groups. In the consumer protection realm, You see watchdogs like Public Citizen or the Consumer Federation of America being very active. In the charity space that we're very familiar with, there's Charity Navigator, there's Charity Watch, there's the Better Business Bureau's Wise Giving Alliance, all entities that are more than willing to lend their resources to state attorneys general. EPIC, the Electronic Privacy Information Center, is heavily involved in trying to shape state privacy laws. It has written letters to state AGs urging them to take action. And then in the final text box, we mentioned local prosecutors. In some states, and I'm really thinking of California here, you have local district attorneys' offices that are quite active, either on their own or in partnership with the state AG's office. So AGs care about consumer protection and they have resources at their disposal. That's great. Now, how do they find you? They can find you in any number of ways. And I think the first bullet is probably the most obvious. It is a mantra that I know Mary and I, and now Jillian in private practice, repeat to our clients all the time. Consumer complaints generate investigations, certainly when they reach some sort of critical mass. And I don't think that there's a magic number. The number can be quite low if the alleged harm is quite high. But AGs find you when they receive consumer complaints. They can receive those complaints directly. Sometimes consumers go on websites like the Better Business Bureau or so-called gripe sites. I'm thinking of something like ripoffreport.com. Regulators scour those sites for complaints to look for patterns. And state AGs also benefit from federal resources, in particular the FTC's Consumer Sentinel, which is a non-public, secure online database of, I think, about 16 million consumer complaints currently. This is data that is available by law to state attorneys general offices and some other federal regulators. The database can be sliced and diced. It can be sorted by state and by type of conduct. And it's a two-way street, not a one-way street. About half of the states are currently sharing their consumer complaints with the FTC, and that number is growing. I think FTC Chairman Joe Simons recently said that the goal is to have all 50 states plus the district sharing consumer complaints with the FTC's Consumer Sentinel database. Disgruntled former employees and other insiders. Another source of information that might trigger state AG investigations. We've seen this with nonprofit clients. We've seen this with for-profit clients. I've seen situations where you might be a very large, very reputable national nonprofit, and you reorganize and you consolidate local chapters. And consolidating local chapters means closing some chapters or displacing some board members, and a disgruntled board member doesn't like it and goes to his or her local friendly state attorney general and complains, and that generates an inquiry. We of course see it on the for-profit side. I've seen written, memorialized strategies, for lack of a better word, written by former senior managers of companies where the strategy is to effectively weaponize regulators against the company. I think the teaching point here, to the extent there is one, is once the investigation is underway, regardless of how it was triggered, you have to defend your business practices on the merits. The investigation is not going to magically disappear because of an effort to undermine the credibility of the source of the complaint. That might play well in front of a jury, but you don't want to get to a jury. So, defend on the merits, and you'll be much better served. Media coverage is a big one. Again, coming from the charity solicitation space. I'm thinking of things like the Tampa Bay Times, which very prominently reports on poorly performing charities. Think of the work that David Fahrenthold did for the Washington Post in investigating the Trump Foundation, leading to action from the New York Attorney General's office. There's plenty of examples abound. And then finally, we've kind of hit on this already, referrals from other law enforcers like the Federal Trade Commission, the DOJ, or the CFPB. So that's how state AGs find you. Once they find you, what are they looking for? And again, this is a non-exhaustive list, but there's, this sort of hits the high points of what we think are hot topics in consumer protection enforcement at the state level, beyond just the catch-all of false advertising. Privacy and data security, there is a lot of state-level activity going on here, most notably California's Consumer Privacy Act, which will come into effect next year in 2020 and will be enforced by the California Attorney General. California Attorney General also is required to implement regulations under the act there, and we're seeing some activity in other states like Vermont and Virginia. A new technological wrinkle here, some states, and I'm thinking in particular of Illinois, Texas, Washington State, have new laws governing the use of biometric data like fingerprints that are enforceable by their state's Attorney General. And of course, there's state AG litigation activity involving data breaches. Debt collection, of course, is a hot topic. I think we've had webinars on that topic before. Anything that is high profile and really goes to the core of public health issues. The opioid crisis being a recent case in point. Some state AG offices focus on particular business practices more than others. Teaching and mentoring space, for example, business opportunities. Most states have their own separate business opportunity rule. Of course, there's a federal law on this as well, enforced by the Federal Trade Commission. But business coaching, business mentoring, really something that is a priority coming out of Utah, also Massachusetts. We mentioned earlier telemarketing, robocalls. Nobody likes them. Republicans don't like them. Democrats don't like them. Same thing with charitable solicitations and charitable fundraising, bipartisan. The California Attorney General recently sued a charity and its principals over allegedly deceptive accounting practices and misleading donors as to how their donations would be used. These are basically meat and potatoes false advertising cases. You cannot lie or mislead a donor with respect to where their money is going, just like any other false advertising case. I mentioned CBD and hemp. I won't spend much time on it, but boy, is it a hot topic. A lot of our supplement clients are going there. The market is going like gangbusters, and there really is kind of I'll say complex and confusing patchwork of what's legal and illegal. Is it hemp? Is it CBD? But what does the 2018 Farm Bill say? What does FDA guidance say? And among all of that activity, we're recently seeing attorneys general from places like Iowa and South Dakota and Alabama issuing statements regarding the legality of CBD in their respective states. So before I turn it over to Jillian, I'll just go through a quick list of state AG case selection criteria. In fact, Jillian, I think, knows this better than I do, but this is compiled from other talks that we've given with regulators and materials that we've seen over the years in our own experience. This includes things like the nature of the harm, right? Has there been significant consumer injury here? How much monetary loss is involved? How many consumers are impacted? Deterrent value, is this a case that would bring high public visibility? Does it have some ability to deter similar conduct from other actors in the same industry. Victims. This one's actually an important one. Who are the victims? I mean, state AGs don't want to see any consumers misled or deceived or harmed, but many states have separate statutory provisions that enhance penalties when the deception is targeted toward the elderly or other vulnerable populations. And like I said before, there is not a lot of unanimity here, right? So I've dealt with the Minnesota Attorney General on this issue, and in Minnesota, 62 and older is elderly. In DC, it's 65 and older, but DC also protects other vulnerable adults, people with mental and physical impairments. So again, you're really going to want to pay attention to each state's statute here, but protecting particularly vulnerable citizens of each state is a high priority. The severity of the violation, I think, is self-explanatory. Is this a speeding ticket or is this a homicide? Is this an isolated compliance lapse, or is this a pattern and practice of unlawful behavior? Who is the defendant? Who's the business being targeted? Is this a good actor generally with some lapses, or is this a recidivist? Is the defendant accused of only of violating state law this one time, or also violating a previous settlement agreement or an assurance of voluntary compliance, which carries more sanctions? Likelihood of success, strength of the case, that basically goes to the merits of the case. We'll talk about resources of state AG offices in a minute, but even for states that have more resources than others, there's always sort of a prosecutorial judgment as to which cases do you bring, which are the low-hanging fruit, which ones do you let lie. You certainly don't want to check so many compliance lapse boxes that you become the low-hanging fruit and are viewed as a slam dunk in court. Some regulators are not afraid to bring test cases and lose, and I admire them for that. But I'd rather defend against a novel and untested theory than a slam dunk case. And finally, and this is a good segue, is relief available through other means? And an example of that is, are there other regulators that have the ability, the resources, the jurisdiction to go after this conduct? Can private plaintiffs do it? And what you'll often see is states partnering with each other or with their federal counterparts to go after deceptive conduct. And with that, I will turn it over to Jillian and the next slide about coordination.
Thanks, Eric. Thanks, guys, for joining us today. Just briefly, I have to give the standard disclaimer that the views I express here today are my own views. They should not be construed as being the views of the Delaware Attorney General Kathy Jennings, nor the Office of the Delaware Department of Justice Consumer Protection Unit. So with that being said, thank you, Eric and Mary and the Venable family, for inviting me down today to talk with you guys about my prior role as a state-level regulator. So at a high level, of course, all regulators that are operating in the consumer space generally have shared interests and enforcement goals. So we're all moving towards the same target. It's just a matter of how we get there. And some of the ways we get there, particularly with regard to widespread issues, are through multi-state or coordinated action. So multi-state action is where you have bad actors or harmful practices occurring across states. So you might have, like, for example, Washington, D.C. is very close to Maryland and Virginia. So you might see that small group join together to address something that's happening in the Metro D.C. area. A coordinated state-federal action is where you have bad actors or harmful practices occurring nationwide. And then you'll see states kind of coordinate with some of our federal partners. Some of the common relationships you'll see are the FTC, CFPB, the FCC. The CFTC and the U.S. DOJ, as well as sometimes the Department of Labor, depending on the nature of the conduct at issue. And then obviously your state attorneys general will join in the effort as well. And the reason we do this is because we need to share resources and enforcement authority. So as Eric mentioned, state AG statutory authority varies greatly by state, takes many different forms. Some states have bifurcated consumer protection and UDAP statutes like Delaware. Some states lack abusive or unfair practices in their UDAP statutes, so that's also a reason why you would maybe want to coordinate with states that do have those. But in any event, the state attorneys general have a lot of resources, and depending on the office, they could have a great amount of resources, or they could be competing for resources with other units within their office. Some offices have criminal and civil, as well as administrative jurisdiction. So that would be an example of Delaware's office. We can prosecute criminally or civilly, or we can bring it before an administrative hearing. Sometimes you have bifurcated jurisdiction. In the charities space, oftentimes you'll have the AG's office enforcing the charitable solicitation statute, and then the Secretary of State's office is responsible for ensuring that you're registering with the state as required under the law. And then also times consumer protection units will have their own special fund where basically anything that they obtain in a settlement or through civil penalties will go into a fund that is specifically for their use. It's not shared in the general fund. It's not shared across the office generally. So those states are going to have a higher amount of resources than states who do have to share out of the general fund. And then, of course, you know the long or sometimes short arm of the law. How far can you reach as a regulator? Can you reach the conduct? Can you reach the actors who are engaging in the conduct? And who's best able to exercise jurisdiction over them? So you'll see combinations at that point as well. So what does coordination look like? We kind of talked about this a little bit already. So you have the multi-state action, which is multiple jurisdictions. This can be several states, or it can be states with a federal partner sharing resources to bring a single action in one jurisdiction. So I will note here, if states want to file in federal court, generally they're going to need a federal partner. Typically they cannot file just 2, 3, 4, 5, 6 states can't file one action in a federal court unless they have somebody like the FTC or the US DOJ joining them. The other kind is a coordinated action. And this is where sometimes it's usually just AG's offices, no federal partner, but multiple jurisdictions sharing resources to bring contemporaneous actions in various jurisdictions. So this, obviously, if you're being sued in 4 or 5 different states all at the same time, is going to bring a lot of pressure to bear on the target, a lot of expense, and potential exposure could be heightened significantly. A lot of times if you end up in that type of situation and you have experienced counsel, you can look towards doing a multi-district litigation that basically coordinates the discovery phase of the litigation and enables you to reduce some expense and some of the duplicativeness of trying to serve discovery in 4 or 5 different jurisdictions at the same time. One thing to consider as well is when regulators are coordinating, generally our coordinated efforts are going to be subject to the common interest privilege. So that's just one thing to keep in mind. We are sharing, we are talking amongst ourselves, and that's generally not going to be discoverable. And other considerations is, you know, does the state have an investigative or an executive deliberation privilege that they can assert as well? But that differs by jurisdiction. So the first thing you're generally going to see, especially when there's a federal partner, is there's going to be an initial demand made. If the regulators think that they have a case, they're oftentimes going to be required to give you that shot across the bow and say, hey, we're aware of this conduct. We will pursue litigation should it rise to that level, but we're going to give you the opportunity to make a presentation or to talk with us, to sit down and talk about what's going on before we get to that level. So I'm sure Eric is familiar with presentations that can happen before the FTC Commission and things like that. Experienced counsel can really help you make the most of these opportunities. And as a former regulator, I would say anytime, as Eric mentioned previously, you have an opportunity to, quote, voluntarily engage, it's going to lessen the sting significantly when you get to the final stages of ironing out the issue.
And actually, I'm going to cut in with a question for you, Jillian.
Sure.
One strategic question that often arises when you go in to meet a regulator is, do you bring the business people or is it just the lawyers? And when you wore your regulator hat, did you find that business people presented well and you wanted to hear from them and not the lawyers?
Right. So I guess it's really about knowing your client and knowing the people you want to bring to that table. Oftentimes regulators do want to see somebody who is involved in management or is on the board who can really talk about what's happening on the ground, the tools or the opportunities to make changes, and somebody who has authority to actually move that change forward. Oftentimes, we as lawyers can talk at a high level, but we don't understand, like, maybe there's this database or maybe there's this process on the ground that's going to create a problem for us implementing the results the regulator wants to see. And giving the regulators the ability to talk through those issues is going to make the process a lot more streamlined. And I think people are going to come out on both sides having a better understanding about how, the relief is going to be affected. Let's see, next slide. So oftentimes the first indication you're going to have that a regulator is interested in what you're doing is you'll receive either a subpoena or a civil investigative demand. Step one, do not ignore this. Just like Eric said, do not ignore a voluntary letter. Certainly do not ignore a subpoena or a CID. They're not going to go away. And most of the time, the regulators have done their homework, and they know exactly what they're looking for. They know the conduct at issue, and they feel that there may have been a violation. So they will continue to pursue you until they get the information they need to make a determination as to whether this is something that is actionable and to what level they should pursue enforcement. Step two, and this is really, really critical, retain skilled counsel who has experience dealing with regulators. I've seen this go really, really poorly for people. In fact, I had a case right before I left the Attorney General's office where we pursued an owner of very large apartment complexes who was doing some really, really terrible things. And we pursued him, and he retained somebody who handles pretty much insurance defense work. That was all he did. No experience with regulators whatsoever. It did not go well for them. We engaged in discovery. That did not go well. We were able to file several motions to compel and ultimately got a sanctions award of $27,000 against this company before they were willing to agree to go to mediation with us. But that would have never, ever happened if that company had retained an attorney who knew what they were doing, knew how to talk to regulators, understood regulatory enforcement, and the powers that the regulators have. So definitely heed my warning. If your in-house counsel does not have experience dealing with regulators, go find somebody outside who does. It will pay off in spades, I promise you. The money you will spend to hire folks like Eric and Mary is well worth it because at the end of the day, your liability, especially monetary payments, could be significantly less because they know how to negotiate and they know what the regulators are looking for and how to accommodate their requests.
I did not pay her to say that.
He did not. Step three, and this is also really critical, and this is something that regulators are going to be looking for. They want to know if you put a litigation hold in place and whether you've started to preserve information. If you're being looked at for potentially violative conduct, the last thing you want to do is be found to have destroyed evidence. Just don't do it. Step 4.
And destruction is kind of a loaded term, but just keep in mind, destruction did not mean that you brought in a bunch of paper shredders and purposely shredded everything. It can mean that you have an automatic deletion in place that deletes any email that isn't saved after 6 months. That's destruction. So you do need to make sure that you're talking to your lawyers and your IT people to make sure that you're not negligently destroying documents either.
Yeah, that's an excellent point. And also another thing too, even if you get that preservation going, once you start pulling down data to produce, you can also destroy metadata through your review of materials to be produced to the regulators. So you want to be cautious there as well. And attorney advisors and IT advisors can certainly be helpful there. Reach out and start a conversation. Clarify what they're looking for, the scope, enter into ESI agreements and protocols, understand what they're going to be looking for from you, as well as obviously the time frame and the timeline for your responses, and continue to maintain those open lines of communications as you move through the investigation. It's critical. And ask questions if you have them. The regulators want to make sure you understand so that they're not frustrated when they get something back from you and it's not what they were looking for. Be forthcoming. I have yet to see an attempt to frustrate, obstruct, or impede a regulatory investigation go well for anybody. If you have legitimate objections, obviously you put them out there, and specialized counsel can help you assert those in a manner that's not going to annoy the regulators. You don't need to self-flagellate, but do not try and affirmatively conceal any misconduct. Again, that's not going to really go well for you. Again, open lines of communication and dialogue. I will tell you probably the number one thing is why I put the first bullet here is we're not going to negotiate against ourselves as regulators. Usually the first overture is going to be via demand. If we're not required to make a demand and you have an open line of communication on a CID or a subpoena, we're certainly open to talking about, what does this look like at the end of the day for everybody? Be willing to engage in those communications, and if you do hear or feel like the regulator is telegraphing a demand or an offer of settlement, make a counteroffer. Like I said, we're not going to negotiate against ourselves. ADR can also be a good option, so keep that in mind as well. And then obviously a lot of regulator settlements involve ongoing monitoring and for compliance with the settlement agreement, so just be willing to accept that if that's something that they're looking for. So just really quickly, I'll go through these last couple of slides because I know we're low on time. Don't be afraid to ask questions. The government is not entitled to go on a fishing expedition. It has bounds to its authority. So if you feel or your counsel feels like there's something that needs to be discussed about what they're looking for, you should talk about having that conversation. Do not underestimate your regulator opponents. Some of the best, most successful attorneys I know work for regulators. Also, they know what e-discovery is, so doc dumps aren't going to work. You should also keep in mind the longer you engage, the more expensive the matter will become for you. Regulators are not paying attorneys by the hour. They're generally not concerned terribly about the costs of discovery or expert witnesses or things like that. Those are all things that you as targets or as companies are going to be feeling as you move through the process. So by adhering to the steps and the tricks that I've kind of put forth here, you can shorten the amount of time you spend under government investigation by cooperating, being forthcoming, and having conversations. I won't talk about the goals because Eric really kind of hit the nail on the head with all of that. I put on here self-report. It's not totally crazy. especially in the age of cybersecurity and data breach laws and a lot of other registration laws that require you to disclose. A lot of agencies will offer opinion letters, and frankly, it's better to know than go ahead blindly and then be subject to a very expensive and time-consuming investigation down the line. And I think, Mary, this is where I turn it over to you.
Yeah, I think one thing that you've all heard repeated time and again today, how time-consuming and costly this can become for you, and that while regulators may not have the hourly billing rates that the regulated parties may be looking against, there are ways for you to offset your costs with respect to a government investigation. And I think that the first place you should always look is your insurance coverage portfolio. And today I just wanted to remind those of you out there of two different types of insurance that I think are probably the most useful for you. The first is called directors and officers insurance coverage. And that does, exactly what you would think it does. It provides coverage to the personal assets of your corporate directors and officers and even their spouses in the event that your corporate board or your advisory committee is sued for the company's wrongful act. Most of the time, directors and officers insurance will also provide coverage for the actual company. But there's a huge misconception that directors and officers insurance is really only something that, Fortune 500 companies should have or publicly traded companies should have, and that's just not the case. If you're a nonprofit with an advisory committee, you should have D&O coverage. If you have any kind of board of directors at your company, even if it's a private company, you should have this coverage. And so we really think that it's very important that you work with your insurance broker to make sure you have this in place. Now, what it will do is in a lot of cases, if you find the right broker and they help you negotiate the right insurance coverage, you can get coverage for these informal government investigations. And that's all going to come down to how your policy defines claims. And it is super important that before you have a problem, you get this good insurance coverage in place. And that insurance coverage is going to define a claim in a sufficiently broad term that it will incorporate any kind of written demand. And that is available. It is on the market. Any kind of written demand for declaratory relief, monetary relief, injunctive relief, or documents. That's certainly something you can look at. And if you get that in place before a problem happens, once a problem happens, all you have to do is provide timely notice, which means when you find out that you're the subject of a subpoena or an investigative demand, you let your insurer know. And then usually your insurer will then provide coverage to help you set off some of your defense costs. It can even help pay for some of the settlement if you do decide to settle with the regulator in question. And these are really important things that can kind of help you stay in business and not spend all of your money trying to, stave off a regulator. Then I also just wanted to make clear, if you don't have a board of directors or you don't have an advisory committee, I think errors and omissions coverage is also a really fantastic and often overlooked form of coverage. If you provide service to other clients for a fee, so you provide consulting services, or you are an IT company, or you're a designer designing trademarks and logos for other companies, you can benefit from errors and omissions coverage. And that is yet another way, and a lot of what we're seeing now in the regulatory space is companies that are essentially regulators are saying are almost aiding and abetting the consumer fraud that another company is doing. And they're either doing that through a process that they're providing, or there's some kind of conduit, they're running the website, they're setting up lead generation. If you have this coverage, or if you are providing this kind of coverage and you have it in place, or if you are providing that kind of service and you have errors and omissions coverage in place with this broad definition of claim, this is once again another place to go when you get that subpoena, so that you have some other place that's providing money for you to defend against the subpoena. And I know we've got about 5 minutes left, so I know we want to take some questions.
Yeah, so we do have a question which I want to address. I want to take 30 seconds to respond or to build on 2 points, one that Jillian made, one that Mary made. With respect to regulators not negotiating against themselves, absolutely right. There is a defense flip side to that coin. I as a rule don't let clients roll over and accept relief that I don't think the state AG could get in court, even if their allegations were all true. And so if that's the starting point, then it almost forces the company, the advertiser, to negotiate against itself. Fencing in is common and permissible. Fencing in refers to when you agree to relief that goes a bit broader than the specific conduct that you're engaged in. There's a bit of a sanction there. That's allowed. It's allowed under the First Amendment. But I certainly wouldn't agree to relief that the state UDAP law doesn't allow. A quick note on insurance. State AGs are getting smarter on this. I think they weren't as smart as they wanted to be 5 years ago, and that's not me talking. That's me repeating what I've heard. It is not uncommon for D&O policies with duty to defend clauses to allow an insurance defense counsel to go out and find experienced regulatory counsel and jump into the case. And we're seeing state AGs ask for information in their CIDs or just informally, do you have a policy? Is there a wasting clause? In other words, something that cuts into the policy limit. At the annual meeting of state charity regulators a couple of years ago, we presented on insurance coverage issues. They were very interested in the topic. So it's just something that Mary was well taken to talk about that as a topic because it's factoring into these investigations. So we have a couple of questions. It's almost the top of the hour. One question: do you have any recommendations if you're a company with customers nationwide? How do you keep up with the pace and variety of industry-specific laws that get enacted? For example, how can companies get notice of auto-renewal laws from Vermont, D.C., and others that went into effect this year? Good question. So, there's options here. Right? We as counsel follow this stuff very closely. It's our job. Some clients ask for 50 state surveys of whatever it is, the telemarketing law, the auto renewal laws, what have you. Lest you think that this is just a business shill, it's not. You could also sign up and get free client alerts from law firms that follow this stuff all the time and that send out notices saying Vermont set to enact auto renewal law in January 2020 or whatever the case may be. When you are a nationwide actor, it can be frustrating, to deal in this patchwork. The safest course is to adhere your conduct to the most onerous state. Usually that's a state like California, not always. But that's not always the answer either. So it really depends on what you're talking about, but that would be my thought there. Yeah,
just to chime in, this is Jillian. AGs are on Twitter, so they're going to probably tweet about developments in the law or new legislation that they've been involved with that has passed. So you can always just follow the AGs on Twitter and monitor their Twitter feeds for postings about new laws and things like that. I don't know about every General Assembly across the country, but some may have listservs or notification lists that you can sign up on, so maybe consider that as well.
Absolutely. We have one more question, and Mary, I'm going to prep you for it, although I have some thoughts also. The question is, can you get insurance after the lawsuit has come in, or does insurance need to be established before a lawsuit happens? And before I kick it over to you, because you're far smarter in this than I am, I'll just note that my experience has been if the client is already involved in an investigation, certainly post-complaint, certainly the lawsuit has been filed. As a practical matter, it's difficult to get coverage because in applying for that coverage, you're going to have to truthfully answer questions such as, are you currently under investigation or litigation or some other thing, and you'll have to disclose it, and your premiums will be very high, or you just won't get coverage as a practical matter. But that's my 2 cents. Mary, do you have any thoughts on insurance coverage after a complaint's been filed?
Yes. Unfortunately, Eric's correct. Almost every single insurance policy I've seen in my 7 years of practice has exclusions, which say you cannot have coverage under this policy if you were aware of a bad act or a claim before this policy was put in place. And in fact, you'll see with companies that renew their insurance policies and disclose certain lawsuits that there will be express exclusions, like FTC so-and-so is expressly excluded from coverage here. So that is a tough one that I really don't know many ways around. That said, that shouldn't preclude you from going out and getting insurance coverage, because just because one action is not covered, that does not mean you won't have coverage for any of the, potentially you could have coverage for the piggyback. So let's see, the FTC has sued you, but, a state attorney general may come in, say from Minnesota, and say, well, not only were you doing this, but you were also, defrauding the elderly. And if we can demonstrate that, for instance, that new claim is different enough, then we may be able to get coverage under the policy that you put in place after the fact for the FTC complaint. So, there's just always a good reason to have them in place. And plus, to be candid with you, if you have a board of directors and you're ever looking for outside people to serve on it, you are going to get the best candidate when you can, for lack of a better word, advertise to them that you have directors and officers coverage. That's going to make sure that you get the cream of the crop. That's what people are looking for, and it will give them some peace of mind. So I think it's always worth it, even if it's not useful today.
And just before we sign off, I just noticed as I'm sitting here, my email address is incorrect. This is Jillian. So if you just change the I in the domain name, so it should be HEGH.law, not HIGH, HEGH.law, if you need to reach out.
Sorry about that. Well, we've reached the top of the hour. Rather than have you stare at our smiling faces on the last slide, we thought our contact information on the first slide might be more pertinent. Thank you for listening. Hope this was helpful, and enjoy the